Hello, I'm Dr. David Juretić, a lecturer in law at Royal Holloway, University of London. In 2008, Peter Chester, who was serving a life sentence for murder, applies to be registered to vote in forthcoming local and European elections. His application was rejected on the grounds that as a prisoner he was ineligible to vote. Prisoners in the United Kingdom are ineligible to vote in parliamentary and local government elections under Section 3 of the Representation of the People Act 1983, which states that a convicted person during the time that he is detained in a penal institution in pursuance of his sentence is legally incapable of voting. The same restriction is placed on prisoners voting in elections to the European Parliament by Section 8 of the European Parliamentary Elections Act 2002. In response, Chester brought a claim for judicial review, arguing that his rights under the European Convention on Human Rights, or the ECHR, and under European Union law had been breached. His claim was dismissed in the High Court and by the Court of Appeal, but he was granted permission to appeal to the Supreme Court. I'm now joined by Katie Broomfield, a researcher in the Department of History at Royal Holloway, University of London, to find out more about this case. Katie, on what basis did Chester argue that the Representation of the People Act 1983 and the European Parliamentary Elections Act 2002 were incompatible with ECHR on the one hand and European Union law on the other?
In respect of the ECHR, he argued that the domestic legislation breached his rights under Article 3 of Protocol 1 of the European Convention on Human Rights, which sets out that free elections must be held at reasonable intervals by secret ballot under conditions which will ensure the free expression of the opinion of the people in the choice of the legislature. He sought a declaration of incompatibility and a declaration that he should be entitled to vote in any future election. In respect of EU law, he argued that the domestic law broke his right to vote. He also said that it was in breach of the general European law principles of proportionality and the right to equal treatment, which were all guaranteed under the Charter of Fundamental Rights of the European Union. In this respect, he sought damages and a reference to the European Court of Justice, the ECJ, at Luxembourg.
And so what did the Supreme Court here in London decide?
The Supreme Court held that actually European law doesn't incorporate a right to vote, and so Chester wasn't entitled to damages, and there was no need to make a reference to the ECJ. In respect of the European Convention on Human Rights, it was slightly more complicated.
Why was that?
In 2001, the European Court of Human Rights considered a similar claim by John Hirst, who was disqualified from voting as he was in prison for manslaughter when he argued that the ban also breached his Article 3 Protocol 1 right.
And what did the European Court of Human Rights in Strasbourg decide in Hirst's case?
They held by a majority that it was the UK's blanket ban on all prisoners voting which breached Article 3 of Protocol 1. This was reaffirmed in 2012 in the case of Scopola and Italy No. 3, in which the UK government intervened as an interested party. The European Court held that the principles set out by the Grand Chamber in Hirst, in particular, the fact that when disenfranchisement affects a group of people generally, automatically and indiscriminately, based solely on the fact they are serving a prison sentence, irrespective of the length of the sentence and irrespective of the nature or gravity of their offence and their individual circumstances, it is not compatible with Article 3, Protocol 1 of the ECHR.
So how do those European Court of Human Rights decisions apply in UK law?
The ECHR is incorporated into UK law by the Human Rights Act 1998, which requires the courts in the UK to take into account decisions of the European Court of Human Rights at Strasbourg. That doesn't mean that the UK courts are bound to follow the decisions in Strasbourg, every time, but as Lord Mance said in this case, where the matter has already been to a Grand Chamber once, or even more so as in this case twice, it would then have to involve some truly fundamental principle of our law or some most egregious misunderstanding before it could be appropriate for this court to contemplate an outright refusal to follow Strasbourg authority at the Grand Chamber level. The Human Rights Act 1998 also requires UK courts, so far as is possible, to interpret UK law in a way which is compatible with convention rights and enables the courts to make a declaration of incompatibility. As Lady Hale explained, it is the court's task to protect the rights of citizens and others within the jurisdiction of the United Kingdom in the ways which Parliament has laid down for us in the Human Rights Act 1998.
So, did the Supreme Court make a declaration of incompatibility in Chester's case?
No, the Supreme Court didn't make a declaration of incompatibility, principally because the incompatibility of the Representation of the People Act 1983, the European Parliamentary Elections Act 2002, and Article 3 of Protocol 1 of the ECHR had already been decided in a previous case in Scotland. In any event, the Supreme Court held that as a convicted murderer, the applicant in this case was very unlikely to benefit from any declaration of incompatibility, and as Lady Hale said, the court should be extremely slow to make a declaration of incompatibility at the instance of an individual litigant with whose own rights the provision is not incompatible. Any other approach is to invite a multitude of unmeritorious claims.
So then, if that Scottish court issued a declaration of incompatibility, what's the effect of a declaration of incompatibility?
A declaration of incompatibility doesn't affect the validity, continuing operation or enforcement of the law in question. It is then for Parliament to decide whether, and if so how, it intends to remedy the incompatibility. And so far both of the provisions remain in force. One of the reasons that the court didn't make a declaration in this case was that Parliament had considered to what extent or whether the law needed to be amended following the decision in Scotland and had made no changes. From the Chartists of the 1830s and 1840s to the suffragettes and suffragists of the 20th century, the demand for the right to vote has long been associated with the claim to citizenship and regarded as the best means of improving and safeguarding individual rights and freedoms. The disenfranchisement of prisoners dates back to the Forfeiture Act 1870, and as Lady Hale acknowledged in this case, remains an emotive subject. As she went on to say, any restriction of fundamental rights has to be a proportionate means of pursuing a legitimate aim. Is it simply an additional punishment, a further mark of society's disapproval of the criminal offence, or is it rather to encourage a sense of civic responsibility and respect for democratic institutions? If so, it could well be that this is more likely to be achieved by retaining the vote. The latter is the position taken by the Prison Reform Trust, who argue that people are sent to prison to lose their liberty, not their identity, and that long overdue reform to the prison service and the lack of interest in the rights and responsibilities of those behind bars stems from the fact that prisoners themselves can't vote. The Supreme Court considered the merits or otherwise of the UK's blanket ban on prisoner voting rights, and by a majority felt that the blanket ban was difficult to defend on the basis of its haphazard effects. Lord Clarke held that it is difficult to see how it can be proportionate to deprive a person of a vote which is relevant to the governance of the state for a period of 5 years, in circumstances where that person may be in prison for no more than 14 days. Alternatively, Lord Sumption declined to regard the loss of the vote in those circumstances as any more significant than the fact that a short period of incarceration may coincide with a special anniversary, a long-anticipated holiday, or the only period of fine weather all summer. The issue has been debated in Parliament, but only minor changes have been made to date. In December 2017, the Justice Secretary announced that prisoners released on temporary licence would be eligible to vote, meaning that they now have the same rights as those wearing electronic tags. Although this change is likely to affect only about 100 extra prisoners per year, the Committee of Ministers of the Council of Europe, which supervises the implementation of ECHR judgments, said it was sufficient to comply with the ruling in Hurst, and closed their case against the UK government in September 2018. In addition, Section 3(1)A has been added to the Representation of the People Act 1983, which allows those serving sentences of less than 12 months in Scotland to vote in local government elections. Should this amendment be extended throughout the United Kingdom? Is the 12-month period long enough, or should it be extended? Should the ban instead be linked to the seriousness of the crime committed? Or, as in France and elsewhere, should it be an additional penalty imposed at a sentencing judge's discretion? Is the current blanket ban on prisoners voting justified? What do you think?